Kevin, let me get the ball rolling a little bit here. One of the things that, I mean, you talked about sort of legal reasoning and how judges and justices distinguish cases from one another. Let's go to O'Brien, because the free exercise thing will come up when you talk about your documents, okay? But go to O'Brien and Johnson. One was decided in 1968, right? Sort of the height of the Warren Court, and everybody assumes the Warren Court is out there expanding free expression, freedom of speech, and the like. They decide against the expression claim. In Texas v. Johnson, a significantly altered court, a court that's altered by a series of Republican appointees, decides by a vote of 5-4 that burning the American flag is constitutionally permissible, that it's part of freedom of expression. Is that, from your study and writing and the way you teach this, is that purely a legal decision?
Well, if we're talking privately, I would say, you know, I think most of what the court, I should back up. I do not think that there are, generally speaking, legally correct decisions I mean, some are more defensible than others, and some I might find personally more palatable than others. But as I'm sure, you know, you tell your students, the whole reason cases get to the Supreme Court is that there's not an obvious correct answer. If there were an easy answer, lower courts are going to find that and sort it out for themselves. So when cases do get to the Supreme Court, I think, you know, there's a strong argument usually to be made on both sides. And I suppose I might say that I mean, you certainly could defend them as legally oriented decisions. I suppose one important distinction is that, you know, maybe in the O'Brien case, you have, as you point out, you have a group of justices that are sort of very concerned about protecting civil liberties and civil rights, but that doesn't mean that they are immune to arguments to the contrary. I mean, so it's not as if the justices are going to protect free expression at all costs. I sometimes think about one of the examples I give in class when I talk to students in the Pentagon Papers case, which I didn't address, but I'm sure you know, because most people saw the movie The Paper with Tom Hanks and Meryl Streep. And most people regard that as sort of documenting what would seem to be, of course, an obvious decision that you allow the press to publish whatever it wants, that the government can't stop the press. But I use the example in class of the Enigma machine from World War II, which you probably are aware of. That's Archibald Cox has to me, a quote that I utilize saying, supposing those justices who were absolutists like Black and Douglas were aware of the top secret code breakers at Bletchley Park and that they had cracked the Nazi code, would they still stand by that original proposition that there were no prior restraints on the press? Probably not. It's hard to, so I think, you know, that's an extreme example, but even here, justices that are committed to free expression can also acknowledge that the government certainly has legitimate interests. The Johnson case, though, is maybe a little bit different case because it was quite a close case. And then after that, the court decided U.S. versus Eichmann, which was the federal flag protection statute as opposed to Texas. And that was a case where I think even Lawrence Tribe, who's a well-known liberal Harvard law professor, had testified in Congress that he thought that Congress's flag law would pass constitutional muster. So I'm never quite sure how to sort these things out, other than to say that I try to piece together the strains of the law that are sensible and that run through all these cases.
As a political scientist, as opposed to an attorney, okay? And this picks up on a question that's in the chat box, which I'll give you in just a second. when you look at something like Texas v. Johnson, you have two sharply opposed views, right? And you've got William Brennan, the great libertarian, writing for the majority. But intriguingly, you've got Etten and Scalia in that majority, silently, but in that majority. So this is a coalition which usually didn't arise in First Amendment cases, or many cases. And you have John Paul Stevens, who's considered a liberal at this point in time, in dissent. So the question is, to what degree does law sort of tamp down political preferences among justices, and how can you use these cases to sort of demonstrate that?
Yes. So as you and I both know, part of the difficulty in talking about law tamping down is that there's typically precedents, multiple precedents that you can cite on both sides to make your legal case. I do think that in the Texas case, I'll put it this way. I would say both of those cases are consistent with a line of expressive cases that would predate US versus O'Brien, which is to say the court had been committed legally to the doctrine of broad protection of free expression. And even today, I think, despite the court's conservative turn, I think it is still largely protective of free expression. That doesn't mean the justices don't have preferences and don't act on them, but I don't think that they can necessarily abandon those longstanding principles that have been, I would say, embedded in the law. So as someone that thinks that the court usually makes decisions based on preferences, I'm not an absolutist in that sense. And so and part of the difficulty in choosing these cases is that they are, I chose them to represent opposite sort of principles. And so there are a lot of, cases that, time, place, and manner restriction cases where I think you have difficulty sorting out what is and is not, how best to handle the case. But I suppose I have to agree with you in the sense that I think the justices do have a fundamental commitment to the law, and they believe that they are following it, and quite often they are. And I don't mean that in a disrespectful way.
Well, and this is what the reason I tapped into Scalia and Texas v. Johnson is there's a question, and I'll just read it straight out. How significant is Scalia's emphasis on originalism? Is it a departure from traditional legal interpretation? How does it affect current conservative majority on the Supreme Court today? And Scalia's argument for the teachers is that he was not reading his preferences into the Constitution, that he was simply applying the text of the Constitution as it was understood at the time it was written. So your response, Kevin, to how significant is Scalia's emphasis on originalism, and how does it play out today?
I'm not sure. So it is significant in the sense that I think he brought to bear for the I would say the legal community the idea of taking seriously what the words of the Constitution meant at the time that they were written. And so if you look, and I have and I suppose, you know what an engram is, right? On Google, where you search for, it'll show you the use of words in books and so on. If you look at the engram of originalism and look at an engram of Scalia, you'll find that the two sort of are relatively modest for a long period of time, and then all of a sudden they sort of take off together. So I'd say, Scalia, one of his great contributions to the court's doctrines is the emphasis focusing people on thinking about what the words meant at the time they were written and how that should inform our decision making. And I think that's taken much more seriously now than it was previously, or rather, it's a much more people talk about it much more commonly than they would have prior to Scalia. But I don't think Scalia relied necessarily universally on his version of originalism. He's like any other human being. If he saw a decision that he would like to make in a particular way, he found a way to make it. I mean, I don't know. So when I read, one of his best opinions is the Heller decision, the gun rights case. That's a great example of originalism. When I read it, I say, my goodness, that's absolutely correct. How could you decide this case otherwise? And then I read John Paul Stevens' dissent, which is another tour de force of originalism. And I say, of course, that's absolutely correct. How could one think otherwise? So as much as important as it is, I think, to perhaps consider what it is that those who wrote the Constitution were thinking, it doesn't provide us a calculus result. It doesn't provide the answer that we would like all the time. And that's one of the things, I'm sorry, one of the things that's really hard for students to understand, especially those that come from the harder sciences, where they want to be, my wife's an engineer. She hates what I do because she can't add stuff up and tell me what the correct number is. I say, well, on the one hand, this, on the other hand, that. It's very hard for people to accept that there is more than one plausible way of reading the law, and that they're both equally legitimate, and that the Constitution doesn't provide the answers to everything, like it's some sort of Rubik's Cube that if we twist it, it all falls into place. It doesn't have all the answers. And that's what I think makes the stuff that we do so interesting and so exciting, is because you have really smart people coming to different conclusions. You're muted again, Joe.
All right, the final part of that question. Go ahead and mute yourself and then I can correct you. Thank you. The final part of that question is, how does it affect the current Supreme Court conservative majority?
That's a good question, and I don't know. I think that there are some conservatives on the court that are, I would say, are traditional conservatives. So someone like Chief Justice Roberts seems to be in the mold of his predecessors. So he seems to be a lot like, let's say, Chief Justice Rehnquist. He's a serious, thoughtful person who cares about deciding cases in appropriate ways, but he is an ideological conservative. You have other conservatives that are really conservative in a way that he is not. So Clarence Thomas has been sort of an island to himself. So he has a lot of very conservative ideas that have not really had much mainstream traction. But you have people like Justice Alito, who is, I think, tilts more towards the, I'm not sure if radical conservative is the right way of saying it, but he is conservative in ways that the court has not traditionally been conservative and is willing to say it. I'm less certain about people like Kavanaugh and Gorsuch and Justice Barrett because I haven't heard enough from them yet to be able to say. But I'd say that the next several years are probably going to tell us a lot about whether the court is going to kind of maintain what you might call a traditional conservatism, or whether it's going to move in a conservative direction that would be a kind of, I don't want to say radical, but a distinctive departure from what the court has done in the past, whether it's going to break with precedents or simply inch away from them.